Good morning and welcome to this webinar on alternatives to a final hearing, an introduction to mediation and the concept of early neutral evaluation. By way of a brief introduction, the format will be as follows. I will talk a little bit about mediation and it's the process that it entails and how best to prepare for that, and indeed particularly touching on not so much the new concept but the newly adopted concept of remote mediation, and then periodically I'll be handing over to Rebecca, who will be talking about early neutral evaluation and its ADR stablemate, the FDR hearing. Suffice it to say, if you would like to submit your questions or any questions you might have during the course of this webinar, we will do they should appear live in the chat function, and we will do our best to answer them as we go through. So with the introduction out of the way, turn perhaps first to a brief description of the mediation process. I am confident that virtually everybody, if not everybody, listening to this webinar is aware of what a mediation is. It's a very familiar process. In very simple terms, it involves the instruction of a third party, a neutral third party, the mediator, whose job it is to facilitate the dialogue between two parties to a piece of litigation. The role of the mediator is, when I do mediation, I always say to the parties, is best defined actually by what it's not rather than what it is. The mediator acts as a facilitator. They don't act as a decision maker. Mediation, as I say, it's a collegiate, collaborative process. It's not an adjudicative process. So it's not like a court hearing, a final hearing. It's not even like an adjudication where the third party imposes a top-down decision on the parties. By contrast, the mediator's job is to work with the parties to help them facilitate their discussions, and indeed to help the parties come to a settlement. But the important part about that is as follows: that it's the parties that settle. With a mediation, you should be very keen to say to the parties that ultimately, because the mediator can't impose a decision, they can't guarantee a settlement. What they can guarantee is that if they work with they can work with the parties, and the parties can work with them, but the parties themselves will come to the settlement rather than the mediator themselves. In order to do this, as I say, it's a facilitative, collaborative process. The mediator might employ a number of different strategies about talking to the parties, listening to the parties, was very important, building a rapport with them, and then within either joint session or individual caucus, talking to the parties, perhaps reality testing some of their cases and their positions, and then hopefully through that process discover what the parties' objectives are, what their intentions are, and then build help the parties move towards each other until a settlement can be achieved. So that, I say, it's perhaps distilled to its simplest essence is what a mediation is all about. It's been around for a very considerable period of time now, as has early neutral evaluation, but it's not something that perhaps most of us are that familiar with. So I shall turn over to Rebecca now, who will be filling us in.
Yeah, so as Phil said, early neutral evaluation is a little bit different and perhaps a bit less familiar. It again employs the neutral third party, but in a evaluative role rather than a facilitative role. So that's the key difference between mediation and early neutral evaluation. So essentially, early neutral evaluation, or ENE, is a form of advanced negotiation. The objective is essentially for the evaluator to provide an opinion which is authoritative but not binding on the parties. So it's going to be something that's going to help you negotiate in future but isn't binding, like something like arbitration, but it's more of a judicial type process than mediation is. As a key part of the process, the evaluator is going to look at the parties' arguments, the key merits of their case, and assess their strengths and weaknesses. So again, differently to mediation, where the parties are encouraged to look at the strengths and weaknesses of their own case, there's someone outside the parties who can provide a definitive opinion. It can be undertaken at any stage in proceedings, so especially before issue, to change your relationship with perhaps time and cost. You might be able to avoid the need for a dispute altogether by just employing an evaluator really early on. It can also be ordered by the court, which is something that we're going to talk about a little bit later. And like mediation, it's becoming more and more common, but unlike mediation, it's becoming a court process as well as a private process for the parties. There's also a lot of use of E&E in business and property hearings, sometimes in the form of what's called an FDR hearing, which is a little bit different to E&E. It's again a form of alternative dispute resolution, financial dispute resolution. And it's often considered together with E&E. So, for example, the Chancery Guide has them essentially used interchangeably, but they are a little bit different. Essentially, the reason for that is that E&E is a little bit more like a court process where the parties would give submissions relatively formally, and then the evaluator would give a decision. FDR is a little bit more negotiation based. So more commonly, the parties will try and negotiate before the evaluator is even involved at all outside the courtroom, and then will go into the court periodically for a steer on various issues from the judge. So it's more like a negotiation, just with the occasional steer from someone, rather than a more judicial type process. Essentially, the courts are looking towards doing much more E&E and FDR processes, and you can actually be forced to engage in early neutral evaluation. That's provided for in the rules. It's Rule 3.12M, which essentially sets out that the court can take any step that it likes in order to further the overriding objectives. So reducing time, reducing cost for hearings in order to make them more proportionate. So it specifically mentions E&E in that process, but equally could apply to FDR or anything like that. And particularly in these times of COVID-19, when lots of hearings are going to be adjourned, it might be something that the courts are going to look to use more often to make sure that parties can have discussions about their cases in a court-type setting. There's a case which is pertinent to this. It's Lomax and Lomax that was litigated in 2019. So the first instance decision in that case said that the court couldn't force people to undergo E&E, but that was overturned by the Court of Appeal, who said that they didn't need the consent of the parties in order to undergo that process. So over time, it's become adopted in the Chancery Division, the Commercial Court, the TCC, and the Family Court spearheaded the way with FDR. I'd just like to note, though, that there's no explicit use of FDR either in the civil procedure rules or in that case of Lomax and Lomax. So perhaps the position on that is a little bit less clear than it is with E&E. But certainly the court's going to start using definitely E&E and possibly FDR a little bit more to get parties to come to agreement earlier and use less court time. So I think we're going to talk a little bit now about how these processes actually work in practice.
Thank you very much indeed. Thank you, Rebecca. Yes, I mean, turning now to the question of how the process works, and explicitly, obviously, mediation. It's a bit of a trite observation, but one of the great advantages of mediation over a final hearing and over, indeed, formal court proceedings is its inherent flexibility. With a mediation, unlike court proceedings and a final hearing, which has a very rigid structure, the parties, there may be opening, evidence, examination chief, cross-examination, re-examination, followed by submission and then judgment. It's a very structured process. Mediation is entirely flexible, and that means it can be adapted to suit the particular circumstances of the dispute or the parties, their particular objectives, and indeed a little bit about the personalities that are involved as well. So it is inherently and almost unlimitedly flexible. Now, so I'll hand back to Rebecca, who'll talk us through how an E&E works.
Similarly to what Phil has said, E&A doesn't really follow any set process. Some court processes will have a set formula that they follow, but for example, in the Chancery Division, there's essentially no direction given as to what specific ways in which you should run an early neutral evaluation. So it's essentially left up to the evaluator or the parties to suggest the best way to run it. And the advantage of that is, again, that you can tailor it to the needs of the individual dispute. So I think we're now going to consider what the benefits and potential disadvantages are of both mediation and neutral evaluation over court hearings.
Thank you very much indeed. Thank you. Well, I'm tempted to say that there are no disadvantages to mediation and everybody should definitely do it, but it's perhaps a little bit more nuanced than that. In terms of the benefits of a mediation versus, and particularly the benefits that it offers over a final court hearing, as I've already previously touched on, one of the big advantages of mediation is that it's a sort of infinitely flexible process. So unlike, I say, the formalised court hearing and the formalised final hearing, the mediation, you can tailor the mediation to both the dispute and also the participants and the kind of personalities and that you might be encountering or dealing with. For example, with a mediation, it may be that one party requires just more of your attention, more of your time. They're not being necessarily difficult, but they've just got more that they want to say. And in terms of, say, facilitating this settlement dialogue, it involves spending longer with them than it does perhaps with their opponents. And so you've got that flexibility, certainly as the mediator and as part of the process, to be flexible. Perhaps, for example, they don't want to necessarily see each other, because particularly if there's a family or an Inheritance Act style dispute where there's a lot of ill feeling, certainly at that moment in time, the party physically being in each other's company is actually counterproductive. Now, you can't avoid that if you go for a final hearing. Indeed, you can't if you go for an early neutral evaluation at court, but you can in a mediation. There are mediations where, which I have done, where we have simply staggered arrival and departure times, and the parties have never put eyes on each other all day. So that's the flexibility that the mediation gives you. Perhaps part and parcel of that is because it's not court, the parties may not be relaxed or entirely relaxed, but they are certainly more relaxed than they're ever going to be in a formalised court setting. That is obviously, there's a double benefit in terms of mediation and the process. You're trying to work towards a settlement. Well, the more relaxed people feel and the more secure that they feel, then the more likely they are to be amenable to discussion and negotiation and ultimately settlement. You also get the situation where, because the parties aren't so tense, it's just, frankly, not a question of being better for them, but it's better on their nerves than going to court. So quite a lot of the time, whilst you temper this, there is a genuine point to be made to people to say this process that we're engaged in now, the mediation, you may be finding this exercise difficult, but the alternatives, be it a neutral evaluation of court, be it frankly a final hearing, are going to be infinitely more difficult. Now, it's not a question of settling because of that, but that is something which you need perhaps to consider. So you've got that sort of double process, and because a part and parcel of the mediation process is the confidentiality element of it. It's an entirely confidential exercise. As I say to people, that there's two layers to the confidentiality. There's confidentiality that happens, that stays around the building the mediation takes place in. So as regard to the outside world, the mediation is confidential and the contents and any offers are confidential. But also you have a confidentiality layer internally between the different parties in their different rooms. So you can discuss and you can say to the parties that they should feel free to discuss with you as the mediator their case entirely openly. Because they can be satisfied that unless explicit permission is given, you as the mediator aren't going to go down the way and say, you never believe what they're just saying in there. It's a question of, and because of that, because people have control over that, they're much more prepared to be open about things. And so a mediation can be a very helpful way of getting parties to really, acknowledge is the wrong word, but parties to sort of appreciate the real issues at the heart of their case, because they feel they can be entirely open with you, because the process is, as I say, is entirely confidential, not only to the court if it doesn't settle, but also to their opponents unless they give you specific permission to do so. So you say this is infinite flexibility. And the final point, I think, which really helps with any mediation, one of the real benefits, is this idea that the appointment of the mediator to third party can really change the dynamics of a dispute. It's pretty obvious that the party there, you have two usually polar opposites in terms of disputes, as between the litigants themselves, and the mediator can come on board as I say, this third party, and change that dynamic, because they can often see, if they stand back, that the parties, the common ground is there. The party just can't see it because they are right in the sort of the heat of the dispute. And that can really make a real difference to sort of unlocking a dispute, because they say the mediator's there as an entirely neutral third party, but saying, are you aware of this? Are you aware of that? Actually, well, I've spoken to both of you. I'm hearing a lot of common ground on this particular point. So that's a real particular advantage to mediation. You perhaps wouldn't necessarily expect me, since I take appointments as a mediator quite a lot, to say there are any drawbacks at all. But of course there are drawbacks. There are drawbacks. There are drawbacks to frankly virtually everything. One of the things I would always say about mediation is that it can be that progress can appear slow. Parties sometimes, particularly when you go into the other room, you get, for want of a better expression, bogged down with the party going through the issues in the case, and there's lots of things they want to discuss, and you take the view, well, actually allowing them to get this all out will assist later in the day when we move towards negotiation and settlement. You can end up spending quite a lot of time on things, and that can make, if you are in the party where the mediator isn't, it can make the process feel quite slow, and undoubtedly a final hearing, unless it's a long trial, is a much more dynamic environment, and people can see, they may not like the progress they're getting, but at least they can see progress happening around them much quicker. There's also this inevitable element, because as I've said a number of times, mediators can't guarantee settlement because they can't. It's not their gift to give. They can't impose a decision. There's always the danger of, if you don't get a settlement, the parties saying, well, that was a complete waste of time. Why did we do that? Because they're going to have to go to a final hearing. Now, not every mediation settles, and part of the mediator's job is to try and highlight to the parties the progress they have made, even if they don't ultimately get to settlement. Because quite a lot of the time, when mediations are unsuccessful on the day, the parties settle in the discussion in the days or the weeks afterwards, because the process of discussion and settlement has been started. And so you want to try and build on that and say to people, you've made a lot of progress, and you shouldn't see this as a failure. And it's true, and it is true how parties do settle afterwards. But there is a natural inclination of, when parties turn up and say, we're mediating today, we're going to settle our case, and that they're going home at 6, 7, 8, 9 o'clock at night having not settled, that they feel, well, we haven't got what we came for. So there is that drawback. Perhaps built into that, there is this question of, it's quite a lot of time, if mediations don't work and they break down, you can actually end up with a degree of entrenchment between the parties, where actually you get people who you feel that, well, we've given everybody who ever settled a mediation. If they pay, they feel like they've given too much. If they receive, they feel like they've had to give up too much. But at least they have the settlement. There's quite a lot of time you get where to guard against, where people become more entrenched because they feel they spent a whole day on something. It's been a cost-bearing exercise. They feel that they've approached the exercise in good faith. They've made concessions, whatever it might be, and their opponents have been unreasonable. And therefore, there is inevitably that drawback which says if a mediation is unsuccessful, yes, it can start the discussion, the settlement and discussion processes, but there is a danger that parties may end up, if the mediation is unsuccessful, in a more entrenched attitude towards each other than they started the day with. That unfortunately is a risk of any mediation, and it's not a risk that can ever be entirely discounted, but obviously it's not a reason perhaps not to do it. So they would say there's some of the, briefly some of the benefits and some of the drawbacks of a mediation. I'm sure Rebecca's going to hand over now and tell us there are absolutely no drawbacks to early neutral evaluation at all. Absolutely,
none I can think of. I will get on to the drawbacks later, but let's first discuss the benefits of early neutral evaluation. As I've said before, it's extremely flexible. And one of the really helpful things to, say, doing early neutral evaluation privately is that the parties can make lots of choices about how the process is conducted. For example, even down to who the evaluator is, who can be chosen for their particular expertise in, say, an area of law that is quite niche. You can look for someone who's really best suited to that dispute. It's also a very focused process and can often be time limited to make it much cheaper. So that tight constraint means that the parties are really focused on those issues and also hopefully really focused on settlement. One of the main advantages as opposed to mediation is that the evaluator can actually become involved in the dispute. So mediation is a lot of suggestion, a lot of conciliation, a lot of, well, have you thought about this? Have you thought about that? And that's completely different because the evaluator can actually make clear points and clear decisions to assist the parties. So it might be a lot more forceful and a lot less party-led than mediation can sometimes be. The parties might also give the view of an evaluator potentially more weight than they might give to a suggestion from a mediator. This might be particularly so where you've got quite a court-type setting for your early neutral evaluation, or indeed the court has actually ordered it. The view of a judge might make a party really sit up and think, what really is the crux of my case, and does it have any merit if this actual judge has told me that I'm probably going to lose at trial? Equally, if you use a trial type process, a lot of litigants are quite keen to have their day in court, come what may. So if there is a typical adversarial type process, parties can feel as though they've had that courtroom experience that they wanted without actually having to go to the cost and time expense, frankly, of going to court and waiting for a year or so for your trial to come to fruition. It's essentially a reality check which is placed on your knowledge of the case. So this is helpful for both parties and their lawyers, because it's frankly quite easy as a lawyer to become involved with your party and think that all of your points are brilliant. So it can be really helpful to have an external view to say, actually, this isn't the best point that you could possibly run, or maybe it might be worth settling now as opposed to later. Equally, it's all about narrowing the issues of the case. So even where settlement isn't achieved, it's going to be really helpful if some points of the dispute do go to trial, then it's going to be much narrower. So you're going to have a shorter trial and therefore less expense again. If you're in the court and settlement isn't reached, that time isn't wasted because you have a judge there. So you can use that judge's time to draw up a case management plan for how you're going to go forward with the case. So again, you can finish much more quickly than you would otherwise. There are, again, a couple of drawbacks. Similarly to mediation, the parties can become entrenched, but in a slightly different way. So the party that, quote unquote, wins the early neutral evaluation, the evaluator agrees with them, can often become entrenched in that winning position and be really unwilling to negotiate with the other side. Similarly, the losing party finds themselves essentially undermined. They might have no ground to stand on and be under pressure to essentially undersettle the matter from their perspective. There might be a lower rate of the decision being accepted than there is in a traditional court hearing, because it's a much quicker process. So the parties might not feel as if they've had their dispute fully aired as they would in mediation or in a longer court hearing. A speedy process like early neutral evaluation is not really suitable for multiple parties or deciding really complex issues of fact. So again, that's something which makes it unsuitable, but isn't necessarily a drawback to the process per se. The other advantage of mediation over early neutral evaluation is that flaws are examined. So in early neutral evaluation, you put your best foot forward and you argue your best case, as opposed to mediation, where perhaps over a longer length of time, or perhaps if the parties are feeling more willing to disclose matters to the mediator, they might unwittingly or otherwise reveal a fatal flaw in their case or something which seriously undermines their negotiation position. So in something like early neutral evaluation, which is a much quicker process, there is the danger that the evaluator might come to a result which wouldn't have been achieved at trial because, frankly, they're not in possession of all the information that they would otherwise be. We're now going to look at which form of alternative dispute resolution you should adopt. It's mediation or early neutral evaluation. Phil, I'm sure you're going to say it should always be mediation.
Well, absolutely. That almost goes without saying. I can cover this point very, very briefly because they are. It's a bit of a glib observation, but it's different horses for different courses. Mediation works very well in a more complicated dispute, one sort of more multifaceted dispute. I'll cover perhaps both, if I may. The early neutral evaluation is very good at resolving particularly legal disputes of a reasonably narrow focus. So the classic example is the interpretation of a contractual clause or something like that. That is, and it's why mediation and E&E together it works well as a hybrid, because you have the E&E can look at that specific discrete point, and then from that you can then deal with in mediation the wider issues between the parties. And so the answer to the question is, it depends what dispute you've got. If you're looking at settling a complicated case which cannot be distilled down to perhaps a single or one or two black or white issues, then mediation is the way to proceed, because you can look at matters, as say, more holistically and without, as say, a rigid structure. Conversely, you've got a point where a case really turns on a discrete question, for example, contractual construction, and frankly, you could lock two people in their room, in two rooms forever, but until they've got a resolution of that point, they are never, the case is going to make no progress towards settlement. Then early neutral evaluation is the way to go. As I say, so it very much depends on the form of dispute that you have. Informs which is of the two versions, mediation, E&E, is the way to proceed. Perhaps if I come now to deal with the more prosaic points of, well, how do I prepare best? How do I get the most out of the processes? Mediation, you can deal with this point reasonably quickly, actually, and say, well, like much of life, and certainly much of legal life, preparation is key. The preparation involved, the amount that people prepare, and this is, say, it goes to both the parties and for the mediator in advance, it pays dividends in the mediation itself. Preparation is, as I've already touched upon, an internal exercise between the parties, experts, the right people coming, and also an external exercise with you or the opposite side. What's going to go in the bundle? Do we have everything? Does the mediator have everything that they need to sort of inform their view of the case? So before they get started, they're up to speed with the position. That process obviously also quite regularly involves the mediator themselves, so you can deal with the practical aspects: who's coming, where are you meeting. All these things can be ironed out in advance of the mediation day itself. In terms of bundles, obviously you produce an agreed bundle for the mediator. It's a question really of providing enough information. There's no hard or fast rule about what is the provision of enough information for the mediator. So it's quite helpful to involve the mediator before you put the bundle together. What's really helpful to see? It may be, obviously, the statements of case or case summaries if you have them, but there may not be statements of case. Mediation can take place pre-issue. But any documents which set out the party's case in short form, that's very helpful. Likewise, if there are key documents, my contractual construction case, if there are key documents that the parties want to rely upon or think the mediator should see, then providing those in the bundle is very helpful. For example, Inheritance Act, estate accounts, you're going to need to see those. In many ways, there's a lot of overlap between those documents and what you might find in the business of property courts within the concept of initial disclosure. I bring those all together so the mediator's got everything they need. Perhaps the witness statements, as I say, there's no hard or fast rules. You may not have witness statements. If you do, it's always helpful to have a witness statement or two from the parties themselves. If you're actually proposing to court trial 14 people to say broadly the same thing, the mediator doesn't need to see all 14 statements, and I should be honest with you, even with setting aside a day to prepare it, probably won't have read all 14 statements either. It's much easier to say, there's a bit of background, hear it from the party, so when you start with them in that initial session, you're starting off from a position of a degree of knowledge, so you can help build rapport with the other side. This is someone who at least knows about my case enough to be able to engage me in conversation about it. And then finally, my question in terms of preparation, it's the position statement. Returning to that, they are very helpful. Maybe you have different ones for the mediator. You can always produce a confidential one for the mediator, which sets out, perhaps to say, a little bit more, the strengths and weaknesses of your case, and then also for the other side, just so everybody can see the parameters of the case itself. And so, I say that in very broad terms, it's a bit of a simple observation. How do I get the most out of it? Well, you prepare for it, but it really does pay dividends. If the parties and indeed the mediator can prepare in advance, it means that you can use the time on the day as effectively as possible. And tying into the point that I made previously about one of the drawbacks, clients thinking, really, what am I getting out of this exercise? The quicker you can make a decent start, and the more up to speed everybody appears to be, the more that allays clients' concerns that actually they're spending the first hour on the clock is going to be spent just bringing everybody up to speed. So that would be my tip for, getting the most out of the mediation. Prepare as much as you can in advance.
I totally agree with Phil. Again, early neutral evaluation is all about preparation. It's meant to be super quick and super cost effective. So the more that you can prepare and agree on in advance, then the more you're going to get out of the process, because after all, you're paying for it. So there's essentially 3 key steps. 1, which issue or issues does the evaluator need to decide upon? 2, how best to set out your argument, if it's either in a written position statement or oral submissions. And 3, which are the key documents that support your argument. And that's essentially the only way that you can prepare for it, but also that the less material that you can give to the evaluator, the more you are going to get out of the process, and also the more easily they're going to be able to make their decision. So I think finally, we're going to look at cost, and then we're going to go on to sort of the future and remote hearings. So Phil, what's a mediation cost?
But very reasonable, I hasten to add. You very briefly touched on it. It's a slightly thorny issue, but every client's going to ask. This is a lovely exercise, and I'm sure it'll be really helpful, but how much is it going to cost me? Mediation obviously is a cost-bearing exercise. The cost can vary depending on the mediator instructed, depending on the length of the mediation. You can have a very short mediation, which may not be all that expensive. You may have a mediation where it's going to take considerably longer, half a day, sometimes a full day, which certainly in my case runs to 6 o'clock, and then an hourly rate thereafter. And it can be and the cost can vary. There's usually obviously built into that a degree of preparation time as well. Pretty obviously, I can't bang on about how important preparation is and then say to people, but of course there's no preparation involved. Of course that there is. But what I always say to people is, and it sounds a little self-serving, but mediation is a cost-bearing exercise. But by the same token, it's considerably cheaper than a final hearing, and it's not as simple as saying, well, it's cheaper so clients like it, but it is a very cost-effective way, even the most expensive mediation, of resolving a dispute. Perhaps if I just to pinch the E&E point about this, early neutral evaluation, particularly if it's conducted by the courts, it isn't cost-bearing in the same way as mediation. There may well be court fees that will be paid, but you're not paying for the evaluator, because obviously the evaluator is part of the member of the judiciary, so it's a court staff. In terms of the costs themselves, though, the parties can agree. They can either bear their own costs, or indeed they can agree that the costs will ultimately be put in the case and picked up by the inverted commas, the loser at the end of the litigation if the evaluation doesn't unlock the dispute and the parties resolve matters. Turning perhaps now, say, to the more modern, the up-to-date issue of remote mediations and remote early neutral evaluation. Actually, that's not true. Remote mediations have been around for some years. They have obviously come into the sort of highlight in the forefront ever since COVID-19. Pretty obviously, the old-style traditional face-to-face of people in their rooms and one person going from one room to the other constantly all day is not socially distant, and certainly not COVID secure, and so therefore people's attentions have turned to mediations. Can they work remotely? And if so, how do they work? For my part, I've only conducted one video mediation thus far, but I can say, and I was a bit of a skeptic, if I'm absolutely honest, before I did it, that can they work? Absolutely, they can. That's not to say that they aren't without their challenges, and they aren't without there are some advantages and some drawbacks over traditional mediation, but they can work. I mean, in terms of just the sheer mechanics, in terms of they're conducted over a video platform, much like this webinar. I've played around with a few of them by common acclaim. The Zoom is the way to proceed on this, because what it has, I think uniquely at the moment, has breakout functions. So you can create, as the mediator, you can create 2 breakout rooms, or 3 breakout rooms if that's what you need. You can pre-assign them to the parties when you invite them, and you can virtually create what you could do previously physically, which is different rooms, a mediator's room, and then you can move the parties around. Makes sense to make sure that you don't move people into the wrong rooms if you can, but in terms of you can put the parties in the different rooms so that you maintain that we don't want to see the other side. But if you later in the day you think, well, actually getting everybody together would really help, or just getting the lawyers together would really help, you can do that virtually, the matter of clicking a few buttons. in terms of the sort of the benefits of a remote mediation over a mediation generally, well, in many ways, actually, it's not perhaps a unique benefit, but it sort of increases the benefits that you see with general mediation or traditional mediation. The parties feel very secure in terms of their they don't even have to kind of come to a barrister's chambers or a solicitor's offices or wherever it might be. They are often mediating from the comfort of their own home. Now that just helps put people at ease. If you're trying to get people to negotiate and feel, perhaps relaxed is not entirely the right word, but certainly comfortable, secure, a mediation when they are doing it remotely really helps to promote that. The other, I think, in my experience, the other good thing about it is that because everybody, to a certain extent, they can't see each other and they're in their own environment, there's no worry about people feeling that the playing field's not level because they've turned up with just perhaps their one other person, and then in walks an absolute army of people on the other side, and they immediately think, well, what's going on here? Well, you don't have that. Because of course everybody is just sitting in their own home. They can see themselves, perhaps they've got their partner or spouse with them, or some for a bit of moral support. But beyond that, you don't have this. Well, how many people are in the other room, and how's this going to work? So that again all helps just relax people, makes them feel secure, which ultimately promotes the settlement process. And it also is perhaps two quick final points. There's also a cost saving element in terms of. You're not paying for venue hire. You're not paying for the fancy sandwiches at lunchtime. You're not paying for travel if that's what you need. That's part of the mediation cost, because everybody can just log straight on and straight off. So that's an advantage, because it's a cost-bearing exercise and it may not be successful. So you want to try and keep the costs under control if you can. And very finally, as from the mediator's perspective, the video platform works really well to sort of read what I call non-verbal communication. People are, if they're sitting in the right place, so approximately a couple of feet away from the camera, you can see their eyes, you can see their hands, you can see their body shape, and of course you can not only see the person you're talking to, but you can see everybody in the room simultaneously. So you can really get a feel for the dynamics between people better than you could if you were just sat at the end of a table trying to keep your eye on everybody in person. It's not to say that there aren't drawbacks. I mean, as I say, there's no perfect solution. It's all compromise. The big on obvious point is everyone's different styles, but I place a lot of store in personal rapport. It's not true to say you can't build personal rapport over Zoom. You can, but it just takes longer. So you're getting across, projecting that sort of personal rapport, building that confidence with the parties is inevitably more difficult over camera because it's remote. You don't have that, that in the room interaction that you would have. And perhaps slightly tied into that, I have noticed that because of that, because it slows things down, because the parties can't, because they're in their own homes, they may go off and do other things. And it's slightly, and you'll suddenly come back, and I should point out this is one of the drawbacks of Zoom as a platform. There's no sort of doorbell function. And you can't knock at the metaphorical door, the virtual door, and say, "Can I come in now?" You sort of just appear like Banquo's ghost in the middle of the mediation. They may not even be there. So that tends to slow things down a little bit, and you have to work that little bit. It's harder, a little bit slower to build that personal relationship with the parties that, in due course, when it comes to negotiation, not a question of trading on, but you're going to need to have built up with the parties. So, as I say, it's not a question of it's all perfect, it's brilliant, why don't we do it all the time? There are some compromises, there are some drawbacks, and there will undoubtedly be some clients where they aren't comfortable with doing it over video. They want to see, for want of a better expression, the whites of people's eyes, and so you have to take that into account. But in broad terms, do they work? Yes, absolutely. The terms of just perhaps finally touching on the tips for remote mediation, it really echoes my point made about preparation and trying to get as much done before you start the actual process, and it's particularly important in video mediations to have a test call. Sounds a really obvious point, but before the day of the mediation, get the parties, get the representatives everybody in on the same time, so you can work out that is everything up to speed? Is everybody's technology up to speed? Can everybody log on? Can everybody hear everybody else? If, for example, you say that you need them to sort of sit back, it's like, are they properly lit? You don't want to spend the whole day looking at a shadow. Converse, you don't really want to spend the initial session before you've even said hello saying, I can't see you, move back, no, you can't. And you want it to be as smooth as possible. Now, it doesn't happen by accident. You can have that test call, and also the test call is a good opportunity beyond, outside the formal day of mediation to introduce yourself. So just start that process of building a bit of rapport with the parties. So have that test call. The other part of having a test call is always have a backup plan. You always need a redundancy. So agree in advance. You don't have to don't have to be detailed, but you can have be it FaceTime. I've used telephone. People keep the video on, but they use the telephone. Anything like that, just so if needs be, you've got something you can fall back on. And then finally, give as between the parties themselves. It really helps with the media. If you're a mediator, get them off the party. If the party, make sure the media's got these contact details for everybody. It sounds like a really sort of trite and simple observation. Make sure you know how to get in touch with the mediator. But of course, you can't just walk down the corridor and knock the door. If everything goes dead or somebody's line drops off, which does happen even if you have a test call, how do they get back in? How do if the mediator is off in a different room and one of the parties drops out and you need to talk to them, how can you get them back? If the mediator, when I did my video mediation, we had a sort of system which came to work quite well, where when the parties were ready for me, they just dropped me an email. I was sitting at my computer, within 10 seconds, back online. And all that you can have those lines of communication set up in advance. So my view would always be to say to people, make sure you prepare in advance, but these little bits, which actually you think, that's an obvious thing to say. Have a test call, get the emails in advance, until of course, the whole thing goes dead, and it's, how do I get in touch with everybody? Am I meant to be phoning? Am I not on my phone? And you can iron all these things out, and the smoother it goes, the more relaxed people are, and the more people, the client feels they've got confidence in the process because, hey, people could hear everybody else. The thing hasn't gone dead. If I drop out, I can get back in touch, and it's all part and parcel of building some confidence. So that would be my few tips for the conducting online mediation. And now for E&E.
Yeah, E&E is something, again, that can be done entirely remotely. Unlike mediation, it can, of course, be done only on the papers, so there's not even a need for a telephone call or a video chat or anything like that. Helpfully, E&E is less about body language, perhaps. If you're only giving legal submissions, it's less important that the judge can see your face. So telephone calls are often used in E&E where they couldn't perhaps be used in mediation. There might be some difficulty, especially when you're giving submissions as a legal representative, in obtaining instructions. So both from my solicitor and my lay client, it's much more difficult because usually they'll be sat behind me. Of course, in hearings nowadays that proceed remotely, I'm not able to simply be tapped on the back or passed a note. So it's worth thinking in advance about how the client's going to give you instructions, and notably to comply with GDPR regulations, of course, it's necessary for that platform to be encrypted. So, for example, Number 5 Chambers runs a separate platform which is all encrypted, or perhaps you could use something like WhatsApp if that complies with your personal GDPR policy. Again, the remote sessions are much more comfortable for would-be litigants. They're in their own home environment, so they might be more amenable to settlement. They might be able to think a bit more rationally because they're not quite as stressed. In terms of addressing people by video link, one of the most helpful things I've found, sounds really silly, is saying someone's name, because you can have 4 or 5 different people on screen, and if you just ask a question, no one's quite sure who you've asked it to. So things like that, just developing new types of speaking practice, can be really, really helpful. In terms of other tips to look at, preparation in advance again. Does the lay client even need to be there at the hearing? Could they just listen in? Could you make sure they mute? You can't necessarily conduct a test call with court early neutral evaluation because a lot of court hearings are using cloud video platform, which isn't accessible to the general public. But again, you can use a different platform like Zoom or Skype to try and make sure that your client's got the best setup that they possibly have. But again, it might all go wrong on the day and you have to have that backup method of communicating with them. The other thing to look at is how your client or the judge is going to follow along with your submissions. So for example, most courts will do their best to lose whichever bundle you send in. So might it be helpful to have a paper bundle for the judge to have on side? Or if you're going to produce an electronic bundle, it's often really helpful to produce something with hyperlinks. So it's easy to jump between the sections and therefore much quicker to conduct the process as a whole. All right, so now we've talked about the modern online provision of ADR. We're looking into the future to see how mediation might develop.
So we're looking at the future, but not particularly far. I think I've written one line here, which is, hint, prepare for more of it. I mean, the basic principle is this, and you can cover this very quickly. It's probably the most of Tri's observation you could possibly make to say there's going to be more ADR. The courts, but it's true. Courts are increasingly focused towards what used to be previously was voluntary is now becoming far more mandatory. Courts before a matter passes over the threshold of a final hearing, courts will expect parties to have engaged in the ADR process. That has it seems to me that's going to be accelerated by two things, or the utility of it's going to be accelerated by two things. The firstly is this. I mean, ADR, be it mediation, be it E&E, offers, say, considerable time and cost savings. I've said even with mediation being a cost-bearing exercise, it's considerably cheaper than a final hearing. There are going to be a lot of disputes. I mean, fixed costs are here to stay, it seems to me. It is only likely that they are going to, the scope of what is covered by a fixed cost is only going to expand from here rather than contract. And therefore, previously there was quite a lot of litigation that was simply uneconomical to fight. That pool of uneconomical litigation just in pure terms of legal costs and recoverable legal costs is going to expand. That's before you've factored in the time costs and certainly dealing with commercial entities, their lost opportunity that they have because they are engaged in litigation rather than say mediation, or be that to say ADR for mediation or E&E. So that's going to be the first element of as fixed costs expand, uneconomical litigation expands in scope, you're going to see more utility behind ADR as a cost-effective way of resolving disputes. And then there's also the more practical and perhaps and sort of contemporary issue of COVID-19. It's not much of a closed secret, as in everyone's aware of this, that of course there are significant backlogs certainly the criminal courts with cases. Well, it's exactly the same with the civil courts. I'm sure we've all had a parade of hearings in the last 3 months that have come through. We've got the orders through saying this has been adjourned off, this has been adjourned off, this has been adjourned off. The courts are working their absolute hardest to get hearings relisted, but the reality is that there is as long as social distancing remains, there is a physical limitation on the amount of cases that can be heard. And therefore, it is likely that the timetable to get matters resolved by way of a contested final hearing is going to be considerably extended from now on. And so therefore, when you've got parties, not just commercial parties who want to get back to doing business with each other, sometimes can be, say, personal parties where they want to just get on with their lives, for want of a better expression, that is going to be aided by using ADR, be it mediation, be it E&E. The quickest way through is increasingly going to become ADR rather than waiting for a final hearing, because, in blunt truth, the list is very long and the backlog is very large, and therefore if parties felt that the legal process moved slowly before, it's going to get considerably worse, and therefore ADR is a good way to truncate that whole process. So therefore, I mean, I say I've rather trodden on Rebecca's point there about E&E, but I think in many ways the point is good for both types of ADR. You use different function, you do different forms depending on what kind of dispute you've got, but the overarching point holds good. There's going to be more of it. Certainly with remote ADR, it's going to become easier to do, and therefore looking into our crystal balls. It's something that we're all going to have to get our heads around in due course. So I thank you. All remains for me to say, and perhaps Rebecca and I, so let me say thank you to everybody for listening in. I hope you've submitted your questions. We will do our best to answer any of the questions that you ask, with the possible exception, he says, looking into the camera, of what's happened to my hairline, which I'm not going to answer because I've got no idea. It just appears to have gone. But other than that, as I say, we will do our best to answer questions, and to say we thank you again. Goodbye.
Thanks. Bye.
Right. Well, thank you all again for watching. And so we're going to do our best now in the time available to answer as many of your questions as we can. The first question is basically about mediation. It's the classic situation one we've all encountered. The situation where the parties don't really appear to be certainly one side engaging with the process until the other side has got metaphorical, indeed sometimes literally, got their coats on. And the question is that an acceptable or reasonable mediation approach? It sounds a bit touchy-feely, but I'm reluctant to say anything's an unacceptable or unreasonable approach to a mediation. I can say this: it's an unhelpful approach to mediation, if I'm honest. I mean, it does play its part sometimes in trying to drive sort of negotiations on, and may be very helpful when you're getting closer and closer and closer to kind of get the deal over the line. But my view is that it's not a helpful position for a party to adopt throughout the afternoon, and until it's only right at the very end that they start to make movement, because it seems to me that it undermines the whole spirit of the process. So what you're trying to do throughout is build a degree of rapport, a degree of sort of understanding between the parties, and a degree of confidence in both the mediator and confidence in the parties. If you're a mediator and you can't get any offers out of the other side, it's very difficult to persuade the party you keep going back to empty-handed that this is a process that A, they should be engaged in, and B, that you've got some traction with the other side. So I think my view is that it's rather an unhelpful approach. I mean, this leads into another question actually about how you deal with a party who's not acting in the spirit of the mediation and generally trying to engage in that, acting unreasonably, and they're basically forcing the other party to make all the movement, and it becomes a one-way street. How do you deal with that? The answer is that this is where it seems to me as a mediator you earn your money. Mediation is meant to be, as a collaborative process. If you've got one party who is just staying on their opening position and not moving and forcing the other party to come towards them, it may be that an imbalance in the case means that is not an unreasonable position for them to start from, because, for example, the case is evidentially very difficult for their opponents. But I think throughout you are trying to then, once you've done that for a little bit, you've got to start with the intransigent party to get across. This is meant to be a collaborative process. The other side, we need to see a little bit of movement from you. It may only be a very small concession. It may only be a very minor point in the context of the litigation as a whole. But even if you can focus, perhaps move away from the big points onto some of the outlying points and get a little bit of progress the other way, just to kind of give this impression of, or not give the impression, to underline it's not a one-way street. And then you can go back to the party that's having to make the majority of the moving and say, well, they have made concessions on this, and they may only be minor concessions, but at least parties have got this idea that everyone's working towards the same objective. And so, as I say, the short answer is, if we've got that intransigence, you've got to get your creative hat on as the mediator and say, how do I get a little bit of progress, even if it's only minor progress, to move things along. Rebecca.
Yeah, thanks, Phil. So the first question for me was whether there are cost sanctions where the parties fail to engage in ENE or FDR. And we're talking about sort of the Halsey decision here back in 2004, where basically the court decided that they could impose cost sanctions for an unreasonable refusal to engage in mediation. Certainly it's one of the things in the court's arsenal, cost sanctions that it could use to compel the parties to do ENE. But we've actually come quite a long way since Halsey. We're moving away from this strong encouragement to do ADR and perhaps more towards compulsion. You'll all know that Halsey stopped short of compulsion, and the question was there really whether it breached Article 6 rights to compel parties to mediate. Interestingly, Lord Justice Ward, who sat on Halsey in 2004, decided a case in 2013. Again, many of you will be familiar with this case. It's Wright and Michael Wright Supplies. And he sort of said, well, the court might in future be querying whether this access to justice point is actually the right one to take. And then we come back up to speed with this case, this 2009 case, Lomax and Lomax, that I referred to during the seminar. The Court of Appeal then sort of dodged the issue a little bit. They said that compelling E&E was actually distinct from Halsey, so they didn't even need to deal with the Article 6 issue at all, which is perhaps slightly irritating. But what they did say is that they said the court's engagement with mediation has progressed significantly since Halsey was decided. So again, it's quite clear that we're moving towards a view where E&E mediation are seen as very valuable by the courts, and perhaps we're looking towards compelling parties to do ADR rather than them just allowing them to do it voluntarily. Back to you, Phil.
Thanks. The next question about mediation is this question about the without prejudice nature of mediation, and can you refer to the agreements, the non-compliance of the mediation agreement in subsequent court proceedings? Mediation, the negotiations are without prejudice. So in exactly the same way that if you were exchanging without prejudice correspondence, the negotiation without prejudice, it covers both the negotiations between the parties, but also information that they relay through the mediator. So the negotiations are without prejudice, but the agreement itself, unless you've got a confidentiality clause, which in itself would always be drafted for an exception for court proceedings to allow it to become enforceable, the agreement itself is referable to in court proceedings for the purposes of enforcing the agreement, because otherwise you I think as the question is. The question, as rightly points out, if it was a blanket situation, you would end up in the position where you had an agreement reached between the parties that was unenforceable because it couldn't actually be referred to in subsequent court proceedings. So the parties can't refer to the negotiation, exactly the same way that if you've got a settlement over correspondence, you can't refer to the correspondence, that's without prejudice until costs. But the settlement itself is an agreement that the court would be able to refer to. While I'm here, I'm just rattling on a little bit. My number one pro and con of mediation. Number one, I've got so many. It's all my favourite thing. No, but in serious, I think the number one pro of it is the flexibility of the process. You can make the process flexible in terms of timing, content, format. You can mould the mediation process around the dispute and indeed around the participants. What's going to work and what. Certainly, when you're sitting as the mediator. Your approach in one case may not be the same as an approach in another case, and that's the flexibility you get. You may spend longer with one party than you do with the other. These are not things you can replicate in court, where it is by its very nature structured. So that's my number one sort of pro. In terms of my number one con, it's in many ways it's the mirror image of the it's not court. The court proceedings, because you're not sitting as an adjudicative capacity, you can't impose the decision. So the parties can't guarantee a settlement. So that means that at the end of the day, now I always say at the start of the day, you can't guarantee a resolution for people. Court proceedings you can. They may not like the resolution, but they're going to get it. Whereas you can't guarantee that in mediation, which means that sometimes parties may have made a lot of progress in the course of a day's mediation, but they're not going to feel like they've made a lot of progress. Certainly the clients aren't. And that can lead to a degree of entrenchment and a degree of the sentiment of, well, that was a bit of a waste of time, wasn't it? And that's something, unfortunately, you can't avoid because you say that the resolution of the case is not in your gift to give. So that would be my number one con of a mediation. Rebecca.
Thanks, Phil. So following on from what Phil said about sort of confidentiality and mediation, I've been asked something similar about early neutral evaluation. Of course, it's not binding, but you do get a determination and perhaps reasoning at the end. I'll first deal with the court-based model. In most court-based E&E situations, the judge who's actually made that decision can't be involved in any further part of the proceedings without the agreement of the parties, because obviously they've essentially already made their decision. So the next judge who gets the case wouldn't know anything about what the previous one had said about the case. Similarly to mediation, in private E&E situations, there is often a confidentiality clause which will cover the entire thing, including the reasoning, so that can't be referred to, because obviously it's the type of thing which would influence potentially a judge if a barrister or someone similar has made a decision about the case in one particular direction. That would really influence their decision. So that's usually not available, but it can be depending on the exact dispute. I've also been asked a question about FDR and whether that's only used for family law hearings. Essentially, this is a method which was really took up really well in the family courts initially, but now it can be used in a civil context or a commercial context for essentially any type of dispute. It's being rolled out much more widely. But again, it depends on the character of the dispute and the willingness of the parties, whether the court's going to look at FDR or ENE. So whether parties might need to be told what to do by a judge, and they might be a little bit averse to negotiating with each other, then ENE is going to be the better method. Whereas obviously, if that's not the case, if they're likely to be more collaborative and they just need a judge steer, then FDR is probably going to be the method which they're going to adopt. So it's a flexible thing for the court to decide, but it's got a few things in its arsenal to make sure that the parties come to a settlement. I think, Phil, you had another question.
Yeah, I have. I've got a couple of questions. I've got a question on a degree of practicality, which is it a good idea to turn up with the mediation with a draft consent or template or common order? And if a settlement arises, is it a good idea to exchange that with the other side in advance of the settlement to show that your commitment to the process? In short answer, yes, I think it is a good idea, actually. I mean, I can tell you from a practical level, it's incredibly useful if somebody already has the bare bones of a settlement agreement drafted before at 8 o'clock at night, everybody's mind's turned to that, because truthfully, that can always be the most difficult thing, to getting it over the line, getting it formalised. So if you've got that process, you've got the document drafted up in advance, that's really helpful. But then I think there's a tactical element, which the question picks up on, which is there some utility in exchanging that with the other side in advance? Again, it's questions of timing, but I think timed well, it can be a very, very good way of demonstrating your real commitment. I think previous question picked up on the idea of what if it's all a one-way street, or feels like a one-way street, as it often does. And of course, if you've got draft settlement agreement in play, you can use that as being firstly as a bit of a prop when you go into the other room. This is the draft agreement that the other party have got. Aren't they committed to the process? Because by the very nature, they've come along with it. And then in terms of, it's also useful because in terms of visualizing for the parties, I think we're nearly there, we're going to settle. Well, here is the settlement agreement. So you can use it in that sense. So I think it really helps to build a degree of confidence in both, the process and the parties. But obviously, what I would say is it's useful to perhaps have your opening position in, but if as neutral as possible is also helpful, because what you don't want to do is basically produce a draft consent or a draft settlement agreement that sets out your top line figure and nothing else, hand it over, because it could look like it could look like an ultimatum. So it's a question of handling it right. But in broad terms, a bit of time spent in advance to prepare an order is a very good idea. And I think that's all the questions on mediation. Have I checked? Well, actually, there's the classic question at the top, which is how has it evolved over the last couple of years? And this question of, do people still use it like a mini trial? The answer is, because it's becoming more widespread, parties are, I think, beginning to get a better handle on the fact that mediation is not meant to be a mini trial. You have to analyse the evidence. Depends which timed. If you time it right at the start, there may not be witness statements, disclosure, expert evidence. Right at the end, you're right at the door of trial. Well, it's absurd to not look at the evidence as it is, because that's what the reality is going to be at trial. But I think parties have got better at not conducting it like a mini trial. It's not a forum for the forensic examination of expert evidence. Yes, you must stress test quality and the credibility of the evidence, because that's part and parcel of why you should settle. But parties got better of this. They're better at this idea of this sort of by proxy cross-examination of the other side. That's not the purpose of mediation. As the mediator, you might say to parties when you go into the privacy of the individual session, well, have you thought about this? It's in that. What do you say about this? But parties have got better at treating it, I think, in the spirit which is intended, which is a slightly higher level opportunity to settle the case without the sort of resorting to the forensic examination that you're going to get at a trial. And obviously, if people say, well, they refuse to move past a certain point, or they refuse to move off, they obsess about a particular point, then as the mediator, you have to sit back and say, well, the reality is you're only going to get a binding determination, a determination, if you go to a trial. Now, you don't want to do that for reasons X, Y, Z. Well, okay, you've got to move past it because of these reasons. But so people have got better at that. And at the point I made, I think, in the talk, you can see it in their position statements. When it first started, position statements were just skeleton arguments with that paragraph about open minds tacked on the bottom. People have got better now about saying, well, actually, the purpose of this mediation, and for this mediation alone, we accept this, we acknowledge that, but they've got to be aware of this, this, and this. And now let's say it's just slightly changed the dynamic. So people are getting better at it. Rebecca, any questions?
Yeah, so a couple more for me to deal with. The first is whether the parties can agree in advance to have the final determination of an ENE be binding. That is certainly something that you can do, and parties are entirely open to put that in the contract that they draw up before they engage in early neutral evaluation. That can be really helpful because it underlines the entire purpose, which is to save the time and cost. So, for example, if you've got a contractual construction dispute, if that part of the ENE is binding, then the parties can only go forward on the rest of the issues. So that's it essentially underlines the cost and time saving element of the exercise if you do make it binding. But of course, you can also decide not to have that decision be binding. And again, it depends on the features of the individual dispute. And I think the final question is essentially how to deal with parties who refuse to engage in ADR or do come to any sort of ADR process and essentially sit on their hands and say, I've had awful situations where people have said, we've come to hear what you have to say. And that's all they've chosen to engage in. And that can be so frustrating, especially when you've set up an ADR session and no one's willing to engage with you or be part of this collaborative exercise. Essentially, all you can do is remind them that this is a really important process for a number of reasons. And of course, as I've already spoken about, the court is starting to become more and more aware that it can put up these pretty harsh cost sanctions on parties who have refused to engage in ADR and they've done so unreasonably. And again, the more that ADR is engaged in by all sorts of parties, the more likely it is that you're going to be unreasonable for not doing it because everyone else is doing it. There's no reason why you're not. So just make sure that when another party is being difficult, that all of that is documented and you can refer that to a court at the end. But I think the way in which most sort of evaluators and mediators conduct these types of settings is essentially to make people feel as comfortable as possible, and therefore hopefully even if they're sitting on their hands at the start of the day, hopefully by the end, because they've employed lots of different approaches, they will come round to the utility of the exercise and hopefully try to engage at least at the end. Right, I think that's all the questions, is it, Phil?
I think so. Or say remains to be said live as well as recorded was thank you very much indeed to everybody who's taken the time out of their busy days to attend this. I hope it's been of some use. And as I say, well, I think if there are any more queries which we failed to answer, I'm sure Rebecca won't mind me saying that if you could just drop us a line in Chambers, we will do our best.
Yeah, do just let us know. I should mention as well that everyone who's attended will get an email through tomorrow with the handout, which essentially is an outline of the talk that we've given and a couple of additional points. So again, if there's any queries arising from that, do just let us know.
Thank you very much indeed. Well, thank you and goodbye. Thanks.